Canada's SR&ED tax credit program was introduced in 1985 by the progressive conservative government of the day. Then Finance Minister Michael Wilson brought it in as a replacement for the failed and seriously flawed SRTC program. Initially, the definition of SR&ED was found in the regulations to the Income Tax Act, Regulation 2900. There's still some stuff there. But in February of 1985, it was included in the definition section, subsection 248(1) of the Income Tax Act, where it is ostensibly more permanent. The theory being that regulations can be enacted and deleted by the government of the day without legislative approval, whereas actual sections of the Act itself have to be passed by Parliament. Anyway, so it has a long history, 35 years. It's been, I think, very successful. Let's take a look at what it means, what it is in terms of a benefit and how important it is to the Canadian economy. So in 2017, there were $3.3 billion in federal incentives and $1.2 billion in provincial incentives. There were 17,000 claimants who filed a little over, I think, 20,000 claims. So some of them filed more than one year's worth of claims. So you file one claim per year. About 50% of the claims were for software or IT, and that doesn't mean for software or IT companies, but for projects that involved primarily software or information technology. And 95% of the claims were for experimental development. The program obviously is quite big. It's over $4 billion a year in total. Total tax incentives. Many of them are refundable, particularly for smaller companies. By that I mean companies in a loss position that earn refundable tax credits for SR&ED can actually get a refund of cash. They're looking at, the program is designed to fund three kinds of research. Basic research, meaning work undertaken for the advancement of scientific knowledge without a specific practical application in view. So in other words, basically university type research. Applied research, namely work undertaken for the advancement of scientific knowledge with a specific practical application in view. Typically, again, these are more like academic projects. And the largest, 95% of all claims, are for experimental development, namely work done and undertaken for the purpose of achieving technological advancement, for the purpose of creating new or improving existing materials, devices, products, or processes, including incremental improvements thereto. So the definition of scientific research and or experimental development talks about basic, applied, or research or experimental development. But what does that mean? In 1998, there was a court case called Northwest Hydraulic, which laid out the 5 steps that were considered necessary to be present if there was to be eligible R&D. It should be pointed out that very few SR&ED cases actually set a precedent, since the facts differ in each case. And however, in this case, there was an exception. The case provides interesting insights, but unless a claim is unusually large, the battle is almost always lost if you don't make it out of the initial review or audit process and have to go to appeal. So clearly, eligible SR&ED is really more an engineering function that happens usually. 95% of claims are for experimental development, and this kind of work is typically done by engineers or technologists. So I thought it's useful. Most of us are perhaps accountants looking at this, but we have to understand that there's an interplay between accounting and documentation and an understanding of some engineering concepts, which we can only understand as accountants somewhat through the eyes of a professional engineer. Anyway, so I put together this PowerPoint for engineers, which looks at a second case which reaffirmed the Northwest Hydraulics decision of 1998. This was the Gentile decision in 2011, and it solidified the approach to a 5-step review of SR&ED. So in May of 2011, Gentile confirmed the 5-step process for determining eligibility. And here were the 5 steps. First, step 1, was there a technological risk or uncertainty which could not be removed by routine engineering or standard procedures? Step 2, did the person claiming to be doing the SR&ED formulate hypotheses specifically aimed at reducing or eliminating that technological uncertainty? You have to remember here that this sounds somewhat academic and scientific, and the people doing the work, while qualified, are typically engineers who are not as academic as university scientists. At any rate, but they do typically have a theory that they put in place and test if they're doing eligible work. So step 2, did the person claiming to be doing SR&ED formulate hypotheses specifically aimed at reducing or eliminating that technological uncertainty? Step 3, did the procedure adopted accord with the total discipline of the scientific method, including the formulation, testing, and modification of hypotheses? So here we introduce the concept of the scientific method. Once again, this was done by a lawyer looking at an engineering process from the perspective of scientific research, which is probably a little different than experimental development. But at any rate, professional engineers that are working in difficult areas do tend to go through a logical and detailed discipline of testing and documenting results. The 4th step is to determine whether or not there was in fact a technological advancement. And as we'll see later on, this isn't really what you might think. We don't actually have to build a new widget that is better than all preceding widgets. It is a little more subtle than that. And then finally, step 5, was a detailed record of the hypotheses tested and results kept as the work progressed. So let's put a little context around this. So SR&ED happens in business to support product development or product improvement. So product development itself isn't eligible. You have to look at if you're doing product development, you have to look at areas where there's uncertainty and where you believe that there are things that are going to be hard to do, and you're going to have to experiment somehow. So in step 1, you ask, why standard practice? Because there will be a standard practice in most disciplines. Why standard practice won't get you where you need to go? To do that, you have to define what standard practice is. Typically these days it's a Google search, i.e. what an average engineer or developer could achieve without very much investigation. You look at, can you buy a solution off the shelf? If yes, then why do shred? It could be too expensive, or it may, existing solutions may only partially meet your needs. Or they may be proprietary and you may be unable to buy them. So we have to define what is standard practice and then determine why it's not good enough. Step 2, we try to find a solution that doesn't exist within standard practice. Framing that solution is effectively building an hypothesis. Once we've built that hypothesis or created the hypothesis, we need to take and save notes describing what we intend to do. Often in a commercial shop floor environment, engineers may have only rudimentary notes at this stage because they're moving quickly to the next stage. So documenting the hypothesis and what you intend to do is important. Step 3, how will you know whether it works? If you need to prove that your solution works, you'll need to collect data and test it. Obviously, if you're looking for funding from an investor or a joint venture partner, you're going to need to be able to reproduce what you've done. Otherwise, no one's going to invest in it, including your own company, if you can't substantiate how it was done. So you need to be able to prove that the solution works. You need to collect data and test and document the plan and the test results. So, was there a technological advancement? Yeah, here, well, you might think in order to have a technological advancement, you need to actually be successful. Well, if your experiment worked and you're successful and built a new prototype, yes, you've got a technological advancement. However, if your experiment didn't work and you proved that your hypothesis was wrong, you've also made it a technological advancement because you've learned. It's the learning that is the advancement, not the technology that you have improved upon. Finally, documentation, step 5. Did you keep a detailed record of activities and results? Note that this step doesn't happen at the end of the process, but throughout. CRA calls it contemporaneous documentation. Without documentation, there's no shred, or at least without documentation, we can't prove the extent of shred, and therefore we can't claim it. In 2017, there was a court case called Formadrain Inc., tax court case number 42. And in this case, the taxpayer was in the business of relining underground pipes without having them be excavated. We can go through the details here and how what they claimed as technological uncertainty. But I think the takeaway here, you can read this yourself, but the takeaway is that all outcomes in a shred case are subjective and fact specific. So 95% of claims are led by engineers performing experimental development. Most engineers don't actually think in terms of hypotheses. That doesn't mean they don't begin with an hypothesis. However, claimants may have difficulty getting engineers to actually articulate what the hypothesis was. Quite often you'll see engineers talk in terms of trial and error. What a professional engineer does in terms of trial and error is actually, it's a red flag to technology RTAs at CRA, but in truth, often what trial and error means to an engineer is formulate a number of hypotheses in quick succession and test them for reasonableness, and then only refine them as results start coming in. So it's still a valid approach. It's just that it's not articulated the way CRA would prefer. Doesn't mean it's not eligible. So there's Forma Drain Inc. from 2017, and also Robotics Solutions. And again, I'll let you read this. This was from a presentation by CRA. But the takeaway here was that not all uncertainties are technological uncertainties. They put the emphasis on optimizing, improving, and minimizing. And even though the Income Tax Act specifically says that experimental development for the purpose of creating new or improving existing materials, devices, products, or processes, including incremental improvements thereto, that's an integral part of the definition. CRA seems to be looking at this with a bit of a jaundiced eye. Again, it's very subjective. So to what extent is improving, optimizing, and minimizing routine engineering, and when does routine engineering and trying to achieve a technological advancement begin? So it can be quite subtle.